Hi, this is Ryan Witt with the Witt Law Group, and we have a lot of clients who haven't gone through the criminal justice system before, so they always have a question about arraignment. And the question is the same thing. What's going to happen at my arraignment today? And they have wild ideas about what's going to happen and that it's some type of mini trial and we're presenting evidence and it's going to have a large impact on the outcome of the case. And I have to tell people the arraignment is important, but really only two things happen. The judge is going to enter a plea, and that's a plea of not guilty. And the second thing is we set conditions of release. And that's kind of the closest thing we get into talking about the facts of the case, because what the judge wants to do at that point in time is ensure that the community is going to be safe. So I'll give the example of a DUI case. If it's a pretty low blow, maybe it's slightly over the legal limit, but it's not a refusal or something really high, the judge will tell the individual to not consume alcohol, not commit any crimes, update their telephone an address if they change it during the duration of the case. But that's about it. So it's entry of a plea, setting conditions of release. If the individual, still the DUI scenario, has maybe a higher blow or they refuse, then we do start to get into the facts a little bit, because the state will talk about whether or not there was bad driving, and we get to refute that to a degree. But rather than getting into a debate about the facts, because the judge is always going to side with the state in this, rather than debate the facts, what you should do is go to court trying to be prepared, showing that you're not a threat to the community. Maybe if you understand that the judge is going to impose an ignition interlock, you get that in advance, or you go set up an appointment to go get an alcohol assessment in advance. So if the state makes a request to take you in on bail, your attorney can say, Your Honor, we've got an appointment to put the ignition interlock in tomorrow, and he's got an assessment tonight. So it allows the judge to say, okay, I can take a risk on this person and they can be out in the community. Because when I say impose bail, what that means is you go into custody and you have to post bail to be released. So that's the two things that happen at arraignment. It's entry of a not guilty plea and setting conditions of release. It's no trial, but with the conditions of release, you do need to be prepared to show yourself in the best light in front of the court so they can release you and they're comfortable in doing so. This is not intended to be legal advice, but it's things to think about, or call an attorney in your community and figure out what should I do in advance of my arraignment so I can be sure to, not be taken into custody. Thank you for watching.